I'm very pleased to welcome Judge Kenneth W. Starr, president of Baylor University, located in Waco, Texas. Judge Starr became Baylor's 14th president in June of 2010. Before that, he was dean and professor of law at Pepperdine University, where he taught constitutional issues and civil procedures. He's argued 36 cases before the U.S. Supreme Court, including Morse v. Frederick, which we will be talking about in a moment. He served as the Solicitor General of the United States from 1989 till 1993, and also as U.S. Circuit Court Judge for the District of Columbia Circuit from 1983 to 1989. He was also appointed to serve as independent counsel for 5 investigations, including the Whitewater investigations from 1994 to 1999, involving then-President William Jefferson Clinton. Judge Starr received his law degree from Duke University, a master's from Brown University, and a bachelor's from George Washington University. And finally, his 2002 book, published by Warner Books, First Among Equals, The Supreme Court in American Life, is an extraordinary read. In fact, in his book, Judge Starr says that the modern Supreme Court is the branch of government with the authoritative role in vital issues that deeply affect American life and politics. Judge Starr, welcome, and thank you so much for being part of this very special First Amendment Symposium at the University of Missouri, Kansas City.
Thank you. It's a pleasure to be here, Dr. Brown.
Judge Starr, let's start with, before we talk about Morse v. Frederick, the quote that I gave from your book where you say that the Supreme Court is the branch of government with the authoritative role in the vital issues that affect American life and politics. You wrote that book and it was published in 2002. Does that still stand today in 2012?
Well, I think so. I wrote that in the shadow of Bush v. Gore, which made the point pretty powerfully on the political side. But very recently, the courts upholding the Affordable Care Act with a number of opinions just reminded the country that even with respect to questions of congressional power and how the exercise of that power touches on the rights and prerogatives of the states and ultimately the liberties of the people, is an issue that is entrusted to the Supreme Court for authoritative resolution. In my book that's now 10 years old, I talk about, among other examples, the Nixon tapes case, which is very familiar to everyone in the audience, and the fact that the court was unanimous and that the President of the United States immediately, willingly abided by a judgment that brought down his presidency and was reasonably foreseeable that it was going to bring down his presidency given the nature of what was on the tapes, just demonstrates, I think, in a very powerful way the authority, including the moral authority, that the Supreme Court has.
Sure. Let's shift discussion, if we could, to the case of Morse v. Frederick, which is also known as the Bong Hits for Jesus case. For our audience, as everyone should know, and we'll be talking about it at the symposium, it all started on a very cold January day back in 2002 when the Olympic torch was on its way to Salt Lake City for the Winter Olympics. And then 18-year-old Joe Frederick was a senior in high school in Juneau, Alaska. And as the torch passes Joe with all the cameras rolling, he unfurls the banner that says Bong Hits for Jesus. His high school principal, Deborah Morse, sees the message, but she sees it as a pro-drug message, and Joe was subsequently suspended. Judge Starr, you were at the time Dean of the School of Law at Pepperdine, and you took on this case and represented Principal Morse before the U.S. Supreme Court. My first question is, what caught your eye with regards to this case to cause you to want to get involved in it?
Well, there are several dimensions. First, it is a free speech case, and that's intrinsically of interest to virtually every lawyer. It certainly is to me. Secondly, it was the context of student speech in schools. And thirdly, I was deeply concerned by one dimension of the case, which was the denial of qualified immunity to the school principal, Deborah Morse, who made this judgment and then executed on that judgment that the banner should come down. And so the probability was, unless the case settled out, that on remand that there would be a trial. And that trial could, in fact, expose the principal to punitive damages. And I think the educational system, I've always been involved in the educational system, whether as a volunteer or as a teacher in some capacity or other. I think the educational system in our country is under enough pressure, stresses, and strains. And so I'll just go ahead and be frank. I was offended by that dimension of the ruling, and so I felt no small amount of moral outrage that a principal proceeding in good faith, you can agree or disagree with their judgment, could face the possibility of punitive damages. Now, people could very well say, well, that's just not going to happen, it would settle out or whatever, but I just felt it was a very dangerous precedent for the orderly administration of the schools, and just dissuades good, honorable people who love the students, who love the education process, from either entering the profession to begin with or remaining in the profession. And indeed, not long after all this erupted, Deborah Morse said, you know, I've had it. She's no longer the principal of the school. She was involved in special ed at the time of the case being argued in the Supreme Court. And I just thought that was wrong, unfortunate, just ill-served the law, and certainly ill-served the public policies informing our educational system.
Mm-hmm. Judge Starr, there are some people, including Joe Frederick himself, who say that this was not a school-sponsored event and that he had the First Amendment rights to express his point of view, the bong, his message that appeared on the banner. What was your point of view on the real purpose of his message?
Well, I took to heart what Mr. Frederick, what Joseph said in his deposition. The case wasn't tried, but in his deposition, when asked that very question, he said it was nonsense. That's not my characterization, it was his, and it was intended to get attention. And so I simply accepted his characterization of it and did not view it as a political statement such as we should legalize marijuana, legalize drug use of another kind, and yet at the same time I viewed just looking at the record, and looking at the photographs, looking at all the circumstances, reviewing the record as I was evaluating the case, I did come very promptly to the view that the principal was simply faithfully enforcing a written school policy that favored student speech. It said we encourage student speech on issues of politics, public policy, and so forth. So it had a very robust pro-free speech policy that was being enforced by the principal, but it created two relevant exceptions. One was a message that could be interpreted as promoting drug use. Another was promoting cigarette or tobacco use. And then there was, of course, concern, as there is in every school, of alcohol use and alcohol abuse. But the real burden, as I saw it, was can a teacher, or a principal in this case, make a judgment, and it's a snap judgment, it's on the scene, things are moving quickly, that particular message could be interpreted as promoting drug use. And bong hits is well known. That has to do with drugs. It does not have to do with theology. It does not have to do with politics. It has to do with particular individual behavior.
Mm-hmm. If students can vote at age 18, serve in the military, legally become independent from their parents, why should the government put free speech restrictions on them when they are in public high schools?
Well, and that's the key. It does seem to me that, and Joseph was 18, and that's a very good point, that he had reached that age where, yes, he could serve our country, can vote, and so forth. And context is critical. If Joseph had simply moved down the street or up the street on Glacier Avenue or at the state capitol, he could have unfurled the banner and nothing would have been said or done. It was the fact that he was involved in a school event. He was not on school property, but he was involved in a school-sanctioned event. And that gives the school authority and jurisdiction. And so what we argued was, and the Tinker litigation will be before the conference, is that this fit perfectly within the so-called Tinker framework.